Every person is concerned about their property after their death. Through a will, a person can ensure as to how his property should be distributed and to whom it shall be distributed after his death. And if a person dies without leaving a will, his property will be distributed according to the law of intestate succession. Hello everyone, this is Farhat Naeem and you are watching India Legal. In today's video, we'll be discussing about the need, eligibility, essential and revocation of the will. Section 2H of Indian Succession Act of 1925 defines will as a legal declaration of the intention of a testator with respect to his property which he desires to carry into effect after his death. There are three features of a will. There must be a legal declaration, there should be disposition of property, and the will must take effect after the death of the owner of the property. Now, what is the need of a will? A well-drafted will helps to avoid family dispute, and in a case if the dispute arises, the beneficiary of the estate has a formidable document in his favour. At times, it has been seen that the deceased had properties, both movable and immovable, which his inheritors may not know. However, a will ensures that all kinds of property are fairly distributed by the testator during his lifetime. Will is a standard legal requirement for transferring real estate, bank deposits, stocks, shares, interest in the business. A well-drafted and registered will ensures the legal requirements are met and there are no bogus claims after the death of the testator. Eligibility to make a will. As to who can make a will. The testator should be of sound mind. He should be free from any undue influence or coercion. The making of the will should be a voluntary act. The testator must be fully aware of the contents of the will. Essentials of making a will. The will should have the details of the testator. For example, the name, father's name, address. The need of making the will should be mentioned along with the fact that the testator is of sound mind and making the will voluntarily and there is no coercion. The language should not be ambiguous. The name of the executor should be mentioned. The will should be signed by the testator and attested by two witnesses. There are some terms you need to understand while making a will. Codicil. It is typically used when a person wants to make a few minor changes to their will rather than creating a new one from scratch, and it is deemed to be a part of the will. Executor. An executor is appointed by the testator as distinguished from the administrator who is appointed by the court. Probate. It is an evidence for the appointment of the executor, and unless revoked, it is conclusive as to the power of the executor. Letter of administration. It is a certificate granted by the competent court to an administrator where there exists a will authorizing him to administer the estate of the deceased in accordance with the will. Attestation of will. It means signing a document for the purpose of testifying the signature of the executants. Lastly, how can a will be revoked? Section 62 of Indian Succession Act deals with the characteristics of a will being revocable or altered any time during the lifetime of the testator. Section 70 of the Act provides the manner in which it can be revoked. A mere intention to revoke is not an effective revocation. The revocation of the will should be in writing, and an express revocation clause would revoke all the prior wills and codicils. Thank you for watching our video. Do like and share it. And for more videos like this, subscribe India Legal.